Hello everybody, this is Mariana Noli from the state of California in the United States of America. I have been asked by my colleague Cristina to provide with a short overview of how our practice has been affected and impacted by COVID-19 and the pandemic. Just a little bit about my background. I'm an intellectual property attorney. I specialize in prosecution and litigation. I help with transactional and licensing as well as some enforcement. So I can give you a little bit of an overview of what has happened as well with the court system, not only on the prosecution side, but also on the litigation side. I became a licensed attorney in Argentina in 2003 and an attorney admitted to practice law in the state of California at the end of 2006. I run my own practice in California. You may recall that on March 13, 2020, our then president declared the state of emergency. And early on, we started to receive notifications from the United States Patent and Trademark Office indicating that if there were deadlines on your previously filed applications that you couldn't meet due to COVID, or applicants could not meet because their businesses were affected by the implications of the COVID-19 pandemic, that you could be excused if you explained the reason. So there was a little bit of flexibility as far as the deadlines if you could not meet a particular action requested because of the pandemic. As far as the patents, the United States Patent and Trademark Office, of course, had as a priority the treatment of the virus, and it did create a mechanism to expedite the examination and prosecution of the patent applications that related to inventions for the treatment of the COVID-19 virus or the SARS virus. That is on the prosecution side. You could be potentially excused for not meeting the deadline, not losing your application. Your patent will get priority in line for examination if it's related to an invention. Also on the copyright side, the United States Copyright Office, which is a separate entity, the United States Patent and Trademark Office, and it depends on the Department of Commerce, issued early on very similar notifications, making sure that applicants, if they could not meet a deadline because they were affected by the COVID-19 pandemic, that you could file your excuse or explain that to the examiner and you could be excused for not meeting the deadline on time. That happened on the prosecution side. In a way, we were very fortunate that in the United States, it's already fairly advanced when it comes to the electronic access to the platforms of the United States Patent and Trademark Office for patent and trademarks, as well as for copyrights. Everything is filed electronically, whether it is the initial application, a response to an office action, submission of specimens of use. So everything is already done online and not in person, as I know in other offices around the world is done in person. So that was not affected. Now, as far as litigation, and of course in litigation matters is a little different. Not sure if you have experience litigating in the United States, but you have two courts, state courts, and the federal courts are district courts, depending. Oftentimes when we're dealing with intellectual property, we're dealing with the federal court system. And the courts are also fairly advanced in their online system of filing. So it's easy to file a pleading, and it's easy to file an answer to a pleading. But of course, the court system was affected more significantly with the COVID-19 pandemic because trials were suspended. They didn't give civil trials, which would be intellectual property priority. Criminal trials were a priority. So criminal trials were suspended for 3 months. That created a backlog. And the civil trials, at least 3 months, and the civil trials were not the priority. So when the federal courts restarted their activity, it was already a pretty big backlog. There are still some difficulties because here in the United States we have jury trial. The courts have to follow very strict guidelines. So as far as the filing, there were not many issues because we have the electronic system of filing. But as far as scheduling a hearing or taking depositions or being in the court, all of that was significantly affected by COVID. Yes, it's true that you could take the hearings via Zoom, electronically, WebEx. Yes, it's true that you could have a hearing or a meeting with the judge. But as far as the jury trials, there is a significant backlog because of the pandemic. I have to say that I think that there are constantly rules that are helping us to catch up with that backlog, but that is the reality on the federal side. And it makes sense that the civil cases that relate to intellectual property are not the ones that have the priority very early on. I will just summarize for you how has COVID-19 affected intellectual property rights in my country, in the United States, as far as the trademarks, the prosecution of trademarks before the USPTO. There were rules allowing applicants to be excused for meeting deadlines if it was because your business had been affected due to COVID. As far as patents, if your invention related to a vaccine or to the treatment, cure, investigation, anything related to the SARS virus and to COVID-19, there were mechanisms put in place to expedite the examination and grant of your patent. For copyrights, very similar to trademark applications, there were rules that made sure that if you miss the deadline because you were affected by COVID-19, that you could potentially be excused upon the submission of an explanation when the time came due. And for the litigation matters, they were suspended depending on the court. State and federal were not exactly on the same timeline, but you could have certain meetings via Zoom or WebEx, but there were no oral trials scheduled, especially jury trials, because the courts would not want to put in danger individuals. I hope that helped with an overview of how COVID-19 and the pandemic has affected IP rights in the United States. And I have to say that thankfully we were already very advanced in the use of online platforms for intellectual property and also for other areas. For us personally, here at Noli IP, we've been working remotely since the pandemic started, and our president declared a state of emergency on March 13, 2020. And since then, we've been working virtually to keep our members safe, and hopefully we'll be able to overcome the implications of this pandemic very soon. Stay safe. Thank you again, Christina, for this invitation. And thank you everybody at the World Intellectual Property Forum for inviting me as well. Stay safe, and I hope to see you very soon in person.